Good evening, students. Today we will discuss a recent decision in which the Supreme Court commented on whether Section 498A violated Article 14. Now, as we know, Section 498A of the IPC dealt with cruelty, and which was basically intended towards protecting women against actions committed by husband or the relatives of those husbands. Now, we also know that there has been a lot of discussion on the fact that this particular provision has been misused. And apart from that, also the fact that it is not a gender neutral law. And there is a reiteration of the conversation that cruelty cannot be only centered around or restricted only as an act which takes place through the channel of the husband or his relatives towards a female only, or towards the woman or the wife only. And thus, because of this conversation, a PIL was filed. So I will share the screen and we can discuss further. Now, if we see the case of Janshruti versus Union of India, this is a writ petition which was filed under Article 32. And primarily, it discussed this very question as to why provisions are not gender neutral, and suggested that guidelines must be framed which are gender neutral in nature, and that there must be legislation which also must center around creating equality between both genders. And then it also specifically talked about the constitutionality of section 498A. Now, the reason why I feel that this particular case law is relevant, because it tells us the opinion, the perspective of the judiciary as to why Section 498A must prevail, right? And that can be an interesting question to ask, that why the Supreme Court continued to feel that 498A, which is not a gender neutral law, must continue, right? Now, the first thing that the apex court pointed out, that there are certain well settled laws under which the court must, enter into trying to interfere with a legislation or a provision, and also situations under which they must refrain from interfering with legislative policy. And they enlisted the same here. They stated that if the legislative policy or mandate, unless the provision is of nature which is devoid of reasonable justification or basis, or actuated by malified or an ulterior motive, lacking a rational nexus with the object sought to be achieved, or is in violation of fundamental rights and any other constitutional provisions, these are the situations under which it was felt that maybe one could have a conversation of interference, apart from which it must not be dwelled into. So the court reiterates this fact, and it expands on it as we or we continue into this particular judgment. Now, the court further states that in the 498A section, which was introduced into IPC, was for a specific purpose. It makes the statement that there was widespread and deeply entrenched exploitation of women through traditional practices such as the dowry system. And the legislature recognized the need for specific legislation to protect women from these forms of atrocities or social evils which were prevalent in society. Right, so the court is highlighting why the legislation was created, why 498A was introduced, and now it starts saying why it feels, or why the Supreme Court feels, the apex court feels, that it does not require interference. It states that it's a fact, or it is true, that there are instances of misuse which have emerged, and which have primarily been done with the intention to harass families or extort money. And these concerns, while present, are rarely sufficient to strike down the statutory provision or dilute its effect. So, thus, it states that when we look into the scales of the misuse and the fact that it is protecting a class of individuals who are vulnerable to a social evil in society, the scales tip towards the protection of women from these kind of social evils. The court has consistently has held in Katina of judgments that a misuse of legal provision does not make it constitutionally unsound, right? It does not make it infirm just because it is being misused, and that is inferred for section 498A. Also, the court has reiterated that while misuse must be guarded against because it has in some instance been invoked unscrupulously, however, this court has also cautioned that it is not to be treated as a tool to prank assistants or as a means to cry wolf. Now, this is an interesting line. The court accepts that 498A is usually and often used to create a false alarm, meaning that there is no veracity to the allegation that has been brought forward. So it has stated that there must be caution in both situations. In every individual case, the facts and circumstances must be looked into with great depth to understand whether it is a false case, a case of misuse, or whether there is genuine cruelty involved in the situation. The court accepts and reiterates the fact that 498 is constitutionally sound. It is not something which is ultra vires, it is not contradictory to the essentials or the aims that the constitution has or protects, right? And it further states that it is protecting a vulnerable section of society, and this line that it states is that it provides institutional safeguards from systemic abuse, highlighting the fact that institutions like marriage also have to have safeguards like the 498A section to protect from internal instances of abuse, internal aspects of abuse which may come in through dowry or dowry demand, and the gender inequality which is inherently or traditionally been part of the institution of marriage through centuries. And the court also reiterates its comment about the same after stating that it is based on positive discrimination, which is provided for under Article 15, which states that there can be special provisions, there can be special classifications, there can be special protection which can be given for the advancement of women, children, or other disadvantaged groups. So, positive discrimination is something which is provided for under Article 15 and must be practiced, and that's what 498A brings in. And the legislative intent and the rationale supporting its enactment is that, and they find no justification to interfere with that legislative process in the present circumstances. They don't feel they are required to cross the boundaries of the legislative process. They accept and acknowledge separation of powers as the judiciary. They feel there is a process available for legislation, and if there has been an acceptance or a reiteration of 498A and Section 84 of BNS, then they feel that, bearing in mind the separation of powers, it is not required at this point of time to interfere with the provision, right? It also states here that the violation of Article 14 as alleged is not as established, it is misconceived and is without merit. This is not a provision which violates Article 14. It doesn't expand, the Supreme Court doesn't expand much on Article 14, but simply clearly makes a statement and says that it is not violating Article 14. It reiterates the fact that each case has to be dealt individually and must be looked into through its layers, through its complexities, to understand whether the case is genuine, authentic, or maybe or maybe a misuse of the provision. The court finally addresses the question of the fact that laws must be gender neutral, and also the aspect that 498A is considered a law which is predominantly misused. But it states now that it must be borne in mind that for every such instance, there are likely hundreds of genuine cases where Section 498A has served as a crucial safeguard for victims of domestic cruelty. We are also aware that certain unconscionable individuals emboldened by rising forward to dismantle such protective provisions, have gone so far as to publicly share videos depicting the exchange of dowry. So the court is hinting that what could happen in case we take away this protection that is provided against dowry and for the protection of women in context of these traditional social evils which exist in our society. It says that if we take it away, there are certain entities, there are certain individuals who still boldly practice dowry, and that practice, that malpractice may perpetuate and may expand further if we take away the protection of 498A. The court also accepted and acknowledged the realities of Indian society. It stated that as a constitutional court and the apex judicial body, they bear a responsibility of safeguarding justice to the entire population and accept the harsh truth that dowry continues to persist as a deeply entrenched social evil. And it reiterates the fact that majority of cases of dowry demand go unreported, and therefore this underscores the continuing need or highlights the need for section 498A, which serves as an instrument of protection and redressal of those who are most vulnerable. So as we sum up this particular judgment, the court has reiterated the fact that 498A may be misused, but the solution to that is to deal with each case with caution and look into facts and circumstances of each case individually. But at the same time, it states that the social evil of dowry continues, and in such circumstance, it is essential that we continue this provision, which works as an instrument to protect women as a class, reiterating that by mentioning Article 15 and Article 14. I think this is a good provision. This is a good provision which is expanded upon by the Supreme Court and could be an interesting question to ask. I hope you found this video interesting, students. In case you want me to take up a particular case or a particular topic or subject, please let me know in the comment box. Thank you.